Hello there, Andrew Bethel with the Bethel Law Corporation, and we are an estate planning law firm located in Southern California. A question that crops up in our office not infrequently is what to do with one's estate when they don't have any heirs to leave it to. Typically, this crops up because our clients either don't have any children or maybe they have some problems with their children. The child might have a substance abuse problem, they can't manage finances very well, or there's just some estrangement in the family. In that situation, we typically go down a couple different options with our clients in terms of what to do with their estate. But in doing so, there are a few things that if you're curious about this, you should know going into this. Firstly, though, the first option we typically run down is family, really extended family. Firstly, if you don't want to leave anything to your children, our next question is, well, do you have any grandchildren? You're not required to leave anything to your children. In fact, you can skip over your children and leave something directly to grandchildren in order to have them taken care of. It's actually pretty common, especially when our clients' children are doing well on their own. Our clients want to take care of the grandkids now. We want to make sure they have a college fund, essentially. Now next, if we're not in that situation, typically we're going to go out to siblings or nieces and nephews. It's not uncommon to where we have clients come in where they don't have any children, but they have nieces and nephews around that they want to take care of. Going out and expanding from there, we look to maybe cousins in that situation. But if we're not going to look at extended family, the next branch we go down is typically friends. Now that's usually very close friends, very helpful people during your lifetime. Those who come in, maybe help you out with some shopping, help you out with repairs around the house, or just somebody you've just been a friend with during your lifetime. We have had instances where clients will leave money not only to their family, but they'll leave us a little something to their friend who they've been friends with for a long time. Additionally, if you have a partner, but you're not married, but you want to leave them something, then that's something you are going to have to put in writing in your estate plan. Just with the nature of that person not being related to you and you not being married, they are not entitled to anything. So if you want to leave them something, you have to put it in writing. Next up is we go to organizations and something we've kind of called CCW. And that's charities, churches, and worthy causes. So charities kind of speaks for itself. Oftentimes, people have some charities that they really like. Usually it's like a environmental related one, or even charities that take care of homeless animals, for instance. Our clients will often pick these charities as the beneficiaries of their estate when they don't have other options, or pick them in addition to whatever else they might choose. Also, sometimes our clients like to leave some money to their local church. They'll leave a little something to the local church because it's a place that is very important to them and not uncommon. Finally, I mentioned worthy causes. And that's just kind of a catch-all to grab any other organizations that maybe they're not a church or maybe they're not a charity, but they are something you would like to leave a little something to in your estate. Usually this comes down to hospitals, for instance, St. Jude Children's Hospital. Another example would be something like a school, your alma mater. You want to leave them a little something in your estate plan. Pretty common things. People do these gifts individually or by themselves, I should say, or they kind of do them in conjunction with other distribution plans in their estate. Very common practice. But something you should be aware of if you don't have any heirs, that is, you don't have anyone, for instance, children that you would leave anything to, just know that the state of California's probate code actually sets out your distribution if you have nothing in place for you. Now in the probate code, if you have no estate plan, that is a will or even a trust, the probate code dictates who your heirs are. And it's going to be similar to the family tree that we discussed earlier. So firstly, the probate code is going to say, do you have any children? If you do have children, those children are going to become your beneficiaries. Following that, if you have children that have passed away, the next question is, do they have children? So your grandchildren. And following the family tree down from there. But if you don't have any children, the probate code goes back up to your parents and then splits off to siblings and down those trees. And if they reach dead end there, it just goes back up. So you are going to have somebody to leave something to, even if you put nothing in writing. But the probate code is just going to dictate that outcome for you. So all that is to say, if you don't have any particular heirs, but you kind of have some people or organizations you want to take care of, you should put that information in writing, because absent any writing, whether it be a will or a trust, the California Probate Code is going to dictate who your heirs are and how much everyone is to receive. Thank you for watching our video. Be sure to like and subscribe to stay up to date on everything estate planning. You can also check out our Facebook, or if you're in California and want to schedule a free consultation or just read a little bit more, you can check out our website, bethellaw.com.